examples of them to show you guys. The case Rogers v. Coons, which he lost, the above one, this was the original postcard by Art Rogers, which was copyrighted, and you can see the sculpture, which Coons had commissioned by a group of artists in Milan to create. This is a case that he lost. It was deemed copyright infringement. The second case that he was in a few years later, Blanche v. Coons, Andrea Blanche photographed the woman in the sandals. It was published in Allure magazine in 2000. Coons used that piece in a painting he had done, or had painted, of 4 feet hanging above Niagara Falls. This case, Coons won. It was deemed fair use. Michelle brought up fair use, and I have from the fair use website what are the 4 factors that help determine fair use, and which come into play. The Shepard Fairey case is about whether or not it's fair use. So the 4 factors are the purpose and character of the use, the nature of the original work, how substantial a part of the original was taken, the effect of the new use on the market for or value of the original work. So those are the 4 factors that help a judge in determining whether or not an artist has used copyrighted work fairly. So I think those are the ones that I'll stop with. Thanks.
Thank you, Jessica. I would like to ask Gary, will you give us some examples, of course, from music? We know that music is a great field for appropriation. Everybody wrote according to Haydn, or according to Strauss, or according to Paganini, and so on.
It's an enormous topic in music, and I don't even pretend to be able to address all of the issues because they are constantly changing as technology keeps changing everything. The way that music can be preserved, recorded, and retrieved is all comes into the copyright situation. And one of the earliest forms of recording music is in the printed form. And I just brought along 2 examples today of some rather famous, world-famous pieces that are no longer under the original copyright. They are public domain. And the first is The 4 Seasons by Antonio Vivaldi. It was written back in the 1700s. This particular printing is copyright 2000. It is under copyright. And this particular edition has enough additional material added to it to allow to qualify for a new copyright. And if you are to make a recording of this, you are going to have to write to the publisher, Bärenreiter in Germany, to get their permission to do so. If you're going to perform it for profit at the Kennedy Center or wherever, you're going to have to get the rights to do so from the owner, and who that publisher that owns it. Here we have the famous opera Lucia di Lammermoor by Donizetti, written in the 1830s. This particular edition has a copyright of 1898, renewed in 1926 by G. Schirmer, which is an American publishing house. That particular copyright covers the original music, any additions or changes that have been interpolated into these pieces. And this happens throughout the history of music, that as time goes by, people would impose deletions, or what we call cuts, or additions, additional notes in the form of cadenzas and ornamentation that suddenly become traditional and had nothing to do with the original composer, but now they're printed in this edition. And we also have in here the original Italian language, and we have an English translation, and that English translation is under copyright as well. So if you're going to perform this work as it still is being performed, The Metropolitan Opera did it this year. A couple weeks ago, they performed it. And I'm sure, since it was broadcast throughout the United States and was done in a live performance as well, that they got the performing rights and paid the required royalties to the publisher for permission to perform the work. We are faced with the same thing in the theater department at this college when we do our theatrical performances. We have Baby with the Bathwater coming up this week, and they have seen to paying the royalties to perform that work. Now, obviously, at this institution, where we are primarily an educational formation, and we charge no admission to the theater performances, our fee for performance royalties would be considerably less than it would be at the Kennedy Center, where they charge very high fees for your attendance. So it's based upon number of performances, size of hall, and the fee that you're going to charge, and what your intent is. Are you a profit or nonprofit organization? We have pieces of music that are written before 1922 that fall under the topic of public domain if the copyright had not been renewed. And now we have the privilege and the luxury of being able to adapt these things, as you have shown us with the visual arts. The same thing can be done with musical examples. And suddenly we have Vivaldi's Seasons playing on people's cell phones. And that's okay, because it's public domain in that respect, that they are, and the way they're presenting it. It's also fair game to use them for commercials and advertising, and for background music for films and other theatrical presentations. But if it's something that's still under copyright, then we have to be very, very careful about not breaking the rules, as is true with all of our areas.
Thank you, Gary. And we shall turn now to the legislative aspect of all these questions that we have posed. But before we do this, and I ask Angela to take the floor, of course, I will read for you one extract of some law that I have found, although I don't know whether it's reliable or not. But the law states that the use of copyrighted image is transformative based on the ordinary lay observer's sense of if the new work is different and how different it is. It is very much of a visual thing, and there is no bright line that artists can go by. So it's a kind of a tricky question, and Angela, can you help us with all this
Okay.
puzzle?
I don't, is this picking up? Can you hear me okay? With what?
The one is picking up the room, and the other
Okay.
is related to the pool.
Okay, so, okay. All right, well, so I'd like to approach this in sort of, in kind of a different fashion and bring together a little bit, or maybe all of what was said. And by posing two questions. The first question is, why should we even have a copyright law, or part of what's called intellectual property law, patents, trademarks, copyrights? And while you're thinking about that, the second thing is from a situation that I'd like to convey and ask you about. And that is, I was just driving down the highway one day listening to NPR, some radio show where an author was being interviewed. And he was being interviewed about his current book. And after that interview concluded, the interviewer said to the author, "So do you have anything else in the hopper? Do you have any new ideas or new books coming out?" And the author proceeded to tell him in almost line item detail about an upcoming book that he had almost yet to put pen to paper, so to speak, but essentially laid out the plot and the characters all in this interview, right? That was my, like, I'm driving like this now. So as to the first question, why should we even have intellectual property protection, such as patents, copyrights, trademarks? And as to the second question, what happens to the author who just laid out essentially his upcoming book for us? Can we take what he said and make it into our own book, essentially?